Hi guys, and welcome to video number 2 of week 5. And in this video we're going to be looking at sections 18 and 29 of the Australian Consumer Law, which is part of the Competition and Consumer Act. And we will also be looking at the restrictive trade practices provisions in the Competition and Consumer Act, and that will kind of round out our discussions of passing off and the situations that might encompass passing off type activity. Okay, so here we go. So here we have section 18 of the Australian Consumer Law, which, as we all know, is Schedule 2 to the Australian Competition and Consumer Act. Applies throughout Australia. This will all just be revision for you guys, because I'm sure you covered this in contract. However, just to refresh our memories, under section 18, a person must not in trade or commerce engage in conduct that is misleading or deceptive or likely to mislead or deceive. And we had a little bit of a preliminary chat about this in our Zoom session in week 4. You'll probably recall the case of Parkdale Custom Built Furniture and Puxu. That's really the big case for the old Section 52 of the Trade Practices Act, which is now morphed into Section 18 of the ACL. So you need to have conduct in trade or commerce, and you'll remember from the concrete construction case there, as long as it's got some kind of trading or commercial character, flavour, if you will, then the conduct will more than likely be up for grabs under the ACL. Under Parkdale, it will be misleading or deceptive if it leads into error or is likely to do so. The Global Sportsman case, which tells us what kind of chance that there needs to be of a consumer being misled or deceived. And remember, they said it doesn't really matter if it's less or more than 50%. If there is a real or not remote chance of consumers being led, then that's the kind of misleading or deceptive conduct that the provision is designed to prevent. Under the Miller and Associates case, we know that whether or not something is misleading or deceptive will be decided as a question of fact. And from the Campermaster Ciudad case, we know that we need to look at the ordinary or reasonable class of consumers. Under Parkdale and Puxu, again, we know that if the conduct doesn't necessarily actually mislead or deceive, but it just causes confusion or wonderment, that's not going to be sufficient. You need to have conduct that would actually mislead or deceive. So there's section 18 in a very brief nutshell. That will normally be, as I said, in the pleadings somewhere where you have a passing off action. Just one other provision that I wanted to bring to your attention here, and I'll scroll down to it. Section 29. And this section really comes to its fore when we're talking about somebody else using a mark that is going to suggest some kind of connection between the original proprietor that's generated the business reputation or the goodwill and the person that's making this rather sneaky misrepresentation.
Because you and me, we're like brothers.
False or misleading representations about goods or services will be prohibited where, and you'll see G and H, they are the ones that you need to be thinking about, particularly in relation to trademarks, signs used as badges of origin in trade. So you mustn't make a false or misleading representation that goods or services have the sponsorship, approval, performance characteristics, accessories, uses or benefits that they don't have, or a false or misleading representation that the person making that representation has some kind of sponsorship, affiliation, approval or whatever by the original proprietor. Okay, so that's two little provisions that might provide some more specific relief when you're talking about circumstances which might suggest a passing off. The last thing I wanted to briefly run through with you was the restraint of trade provisions in the Competition and Consumer Act. It's more than likely that you will have covered off restrictive trade practices either by way of your contract law unit or possibly your corporations law unit. I used to teach it in my corporations law unit at QUT. So we have Part 4 restrictive trade practices, and the provisions that I want you to kind of get your head around in relation to IP are just a few of them. I have put in the readings this week some of the outcomes of the competition policy review. It looks like we will be in for some changes here to these provisions, although the more far-reaching suggestions of that review were not accepted by the government, so they are going to engage in further consultations before they change anything on a few of these. But Section 45 deals with contracts, arrangements or understandings that, see subparagraph 2 is the most often used, has the purpose or effect or likely effect of substantially lessening competition. That's one of the more general provisions, and it gets thrown into most pleadings. You'll see here we have subparagraph 1, all worried about things that happened before 1977. It looks to me like the government has agreed to take those provisions out. They're really not terribly useful anymore, so we'll go straight for the paragraph that I've just mentioned there. That will stay in Section 45. The next provision we need to talk about is misuse of market power. This provision has caused a lot of angst in the case law, and particularly the horrid little phrase take advantage of, and what exactly it means for a corporation to take advantage of its substantial degree of power in a market. I mean, it's one thing to have that substantial degree of power. It's another thing to actually take advantage of that power for the purposes of, and here it must be one of these three naughty purposes for it to fall within Section 46. Now, from what I can see, the Competition Policy Review suggested some fairly far-reaching reforms of this provision. They wanted to get rid of this horrible little confusing phrase here, take advantage of, and they wanted to get rid of these enumerated purposes and just pop in there the good old substantial lessening of competition test. Sounds very reasonable. Unfortunately, the government was not prepared to accept that, wants to engage in further consultations. So it looks as though we're stuck with this provision as it stands for the moment. I have set the Universal Music and ACCC case as you're reading on intellectual property and restraints of trade for this week. You will see that the lower court judgment in that case, the court actually concluded that Universal had market power and contravened this section. However, Universal had only, I think, maybe 17% market power. Warner Music only had about 16%. So on appeal, the decision that they had contravened Section 46 was actually struck out, and they were left with their contravention of Section 47. So if we go down to 47, exclusive dealing, we will see that the main prohibition against exclusive dealing is in subparagraph 1, and then it leads naturally to the question of, well, what exactly is exclusive dealing? And that is fleshed out in the following paragraphs of this provision. You will note, even if you do engage in the practice of exclusive dealing, it's not going to contravene section 47 unless you also satisfy subsection 10, and that conduct will need to substantially lessen competition. Okay, so exclusive dealing, and in the universal case, the paragraph that applied was a supply or offer to supply on condition that the person to whom the corporation supplies will not, except to a limited extent, acquire goods and services from a competitor. And what you had there was Universal Music and Warner supplying, at that stage, compact discs, musical compact discs, to a number of music retailers. And at that point in time, there was a change in legislation allowing music retailers to import genuine copyright authorised copies of compact discs from overseas. Prior to that, if you wanted to import something from overseas, you had to get the permission of the Australian copyright holder. After the change in legislation, you could source your CDs from wherever you wanted to, as long as they had actually been authorised by the copyright holder in the jurisdiction that you were importing from. So you still couldn't import pirated copies of CDs, but you certainly could import cheaper copies of CDs from countries like Malaysia, India, Indonesia, the countries that were able to produce those CDs quite cheaply. I think it was Malaysia and Indonesia that were at issue in that case. And Universal and Warner had actually said to their music retailers, look, I know that you've bought imported copies from overseas, cheap imports. We know that they've been authorised by the copyright holder over there. However, we are not pleased about it. And they actually closed the music accounts of a couple of smaller retailers, which sent a signal bubbling through the industry that, hey, we better not import these cheaper copies from overseas, because otherwise Universal Music Australia and Warner in Australia won't supply us with their catalogue of CDs. And the retailers were particularly concerned about maintaining their relationship with Universal and Warner, because they were able to supply certain back catalogue CDs that the music retailers wanted to get their hands on. So most of the other music retailers fell into line and agreed not to buy cheaper imports from overseas. And then the ACCC found out about it after one of the music retailers got quite annoyed, stepped in and said, hang on a minute, this is exclusive dealing. As I said, in the lower court, they went down on Section 46, misuse of market power, and also Section 47. There was a fine imposed of $450,000 for each of Universal and Warner, and interestingly, 2 executives from each of those companies also had fines imposed against them. On appeal, Section 46 fell away, but they were still left with a contravention of Section 47. And unfortunately for the executives, their fines remained. And in relation to the companies, their fines were increased from $450,000 each to $1 million each. So that's the Universal case. There was some suggestion that Section 47 would be reformed after that competition policy review. The government didn't accept that, and so it looks as though we are going to be left with Section 47 as it stands. Section 48, resale price maintenance. We are not allowed to set resale prices for our downstream distributors of our goods and services. So we know that that is a per se prohibition. And the only reform that was suggested to that provision was that it should be notifiable. And we do have a regime that applies to most of the provisions in Division 2, whereby if you know that you are going to be engaging in this conduct, for example, you do want to impose some kind of restrictive term, then you can notify the ACCC first up and get them to authorise your conduct, or you can do a notification provision, which is something similar to an authorisation. And then you'll be able to engage in the conduct and you won't be at risk of contravening the sections and the wrath of the ACCC. So resale price maintenance going to stay, but probably will be notifiable. The government's accepted that. And the only other provision that I really wanted you to be aware of was Section 51.3, which we've already spoken about earlier on this term. And this is the exception for intellectual property provisions. And this provision looks as though it will most likely go. There seems to be no good rationale for accepting anti-competitive terms in IP licenses just because they're IP licenses. And I think that's a reasonably sensible position to take on that, particularly given, as I said, that the provisions had very, very little use and has been the subject of a lot of complaint because of its complexity. So they are the restraints of trade provisions in the Competition and Consumer Act. Have a little look at the Universal case. It's a really interesting case of IP rights being used in a fashion that is quite coercive and quite chilling on conduct in a particular industry.
You'll laugh, you'll scream, you're disgusting.
So that's really all I wanted to say about IP rights and restraints of trade. I hope that all of this is making sense. If not, post me a comment in the forums, email me, and we can certainly sort it all out. Other than that, thanks for watching. I hope you enjoyed this video. If you did, give it a big thumbs up and subscribe. And hopefully I'll chat with you in the next Zoom session or in the forums. Thanks, guys. Bye.